participants and attendees in this conference, benevolence of the development of the mediation in the regional level. And I would like also to thank, of course, the CCSP that enabled us to meet today to discuss about the enhancement and strengthening of the mediation, which is a very important link in our legal system in our countries. And I would like to thank also the head of CCSP, Mr. in Kosovo, Mr. Bikim Ismaili, who is a distinguished worker and is a very sincere vis-a-vis his work to the enhancement and expansion of the mediation in Kosovo. And last but not least, I would like to thank the German taxpayers who, with their support, we managed to convene this conference. I'm very pleased and honored to be in this conference today when we're talking about the mediation part. And with regards to the part of mediation, I'm quite sensitive when the discussion takes place because of professional aspect and academic aspect. I'm in depth involved in the part of mediation and also all the stages it went through and is going through this part of the mediation. I would like to commence with my part of presentation with that many times and one question is asked: who is writing the law? Who is writing the justice? And this is the moment when I got to understand that justice is written by the needs and requirements of the citizens. And this was across the history and even today. And also the part of mediation is a part of the law. It's a request by the citizens in a social demand, which gave rise to the demands that arose from the citizens' side. And this leaves us to understand that we have had an increase of the awareness about that today the citizens are willingly to enter into the mediation because the mediation provides solutions, resolutions. Therefore, the mediation vis-a-vis the national policies and system, it's a need that needs to be enhanced, developed, and to become and reach at the same level to become a integrated part of the justice system of a country. It's a very important to have a mediation to at that appropriate level, but also to have a quality of mediation, quality of mediators for the mediation to be indeed the right path, the option of the resolution of the disagreements and disputes. So the with a part of the quality of the mediation is in his initial part. The mediation should be a component and full part of the legal system of a country. By being a full part, component of the system, and then we will have it regulated, governed by the existing legislation, but also to have it regulated within the laws and to be in harmony with the other parts of legal system. The second part is a very important part. It's the continuous professional training of mediators, which when I say the continuous professional training of mediators, I mean to enhance the quality, which means amendments of the policies and legislation, but also with the part of the agreement itself, but also the presentation skills and communication skills with parties when we know that the mediation is nothing more than a part of communication between parties. And the third element, which is very interesting and highly important, is a required condition for mediation, the certification and licensing. All the countries here, which I have beforehand attentively listened them, when it comes to the part of certification and licensing of mediators, here I think that the requirement and condition should be aligned with what is required for the future mediators to be ready and committed and prepared professionals in professional field, and being aware of the circumstances and the culture of the country to ultimately become a successful mediator. In many countries, we have different conditions and requirements for the licenses. When I say different, they are more, let's say, more easy and more difficult. In Macedonia, it's quite difficult, but of course, they will produce quality amongst their mediators. Another part which I have identified, and I'm speaking about the scientific and practical sense, is specialization of mediators profiling. What does it mean? This means that the mediators take into account their academic background and professional background. They should be have a specialization in the field of a law, because they have to be ready to embark into the mediation, particularly to those specific topics that require mediation and the knowledge. So they should have, because it involves the commercial law, private rights, and also the children's rights and administrative rights and all these. So another element which enables us to have a good quality with the part of mediators, mediators, is the countries that have that in place, the final evaluation of mediation agreements to be uh, evaluated by the judge, prosecutor, administrative body, that it will be have a full recognition, become all powerful, and will lead to the legal effect. And of course, this doesn't go beyond the authority of the mediator or mediation, but it happens that sometimes if it comes into the contravention or in conflict with the legal norms or something like, then it's the judge in the final instance that will prevent or for an agreement to enter the force and to produce a legal effect, because even in our content there were not some elements included, because they were not very well established when it came to the resolution of that conflict. And another element very important is execution of mediation agreements, for the very fact that if the mediation agreements does not manage to produce a legal effect, and then the quality of mediation itself, which also is closely related with the public trust, then we will see the decrease or condescending of the trust of the citizens. So I would like to relate element 6 with the first part of item completion according with the legal system. Let us take this into the account. From as soon as the mediation starts, the mediation agreement should have an appropriate title for the for me, and in that mediation to produce an agreement will have a legal effect, and the parties will acquire their rights according to that mediation agreement. What it's very important element, as I said, these 6 elements which I consider of the highest importance and have a deep impact in the quality of mediation, but also the mediators. For the mediators to run the mediation with highest professionalism and trustability, because this, at the end of the day, will have the impact on credibility of the public, general public, because the general public should consider the mediation as the access to justice, because there are a lot of positive aspects, and was discussed before. It's a lower cost, it's a more expedited proceedings, and also the human relations will improve, will become better than before the mediation starts. I would like to close this with like a humor that the part which remains, I hope that we will meet the next year in the conference where we are going to discuss this in person. Thank you very much for the given opportunity.
Yeah, thank you very much, Yusuf. Actually, this is what I was about to propose. Maybe not to leave the second part of your presentation, which was meant to focus more on the relevance of good quality for the trust building and the judiciary. maybe not to leave it for next year, but maybe to leave it for the discussion. So please, if you're in particular interested in this, dear participants, also raise your questions in this respect. And if not, thank you very much for this very comprehensive summary of the conditions under which good quality of mediation services are possible. Thank you very much for the moment, Isuf, and I'm sure we will come back to you and to your assessment during the discussion. So I'm very happy to introduce my next panelist, to whom you were already introduced yesterday, since she was our keynote speaker. It's Gordana Ristin. I'm very happy to have you here and that we have a new opportunity to hear from you and from your experiences. Just to shortly introduce you again, you're a mediator and judge at the High Court of Ljubljana, and you're the head of the Courts Department for Alternative Dispute Resolution, which I think is in particular interesting. And you are the president of the Slovenian Association of Mediators. You have been a mediator since 2001, so I could imagine you have been one of the pioneers of mediation in Slovenia, and you have been mediated more than 200 cases. You're also teaching and lecturing about mediation and alternative dispute resolution. Yeah, thank you very much for being part of this panel. And to give you the floor, I would like to ask you, from your experiences as a mediator, president of the association and judge, to what extent can formal qualification ensure quality of mediation services, and what else do we need to do? So a little bit the question, how far does formal qualification bring us, and what else do we need? Thank you very much, Gordana.
Dobar dan opet svima I hvala na pozivu za učestvovanje u ovom drugom.
Thank you very much, and thank you for the presentation. Do you have the translation? Can you hear the translation? Now I just shifted into Portuguese. Do you hear me? I'm going to talk rather from the perspective of our association of Slovenian mediators that consists of over 400 members and has a long background. And what we consider to be significant while talking about the mediation quality, we had several roundtables, conferences regarding this topic, and of course that we are following everything that is going on. Somehow I have extinguished when it comes to the quality of mediation. I would say that the assessment or what can actually have an impact on the quality. This could be seen from different levels. The time before we start the mediation, how we have arranged, how can we create actually the mediation as how to refer the case is this as it is required by the profession. We can make errors or mistakes even on this. Who is calling who? If there is an initiative, is here allowed to invite the mediator, or maybe is it the mediator the one who should inform both the parties, or is there any delegation? We have such a thing in the mediation center. So how to choose, select the mediator. This is very interesting also to be heard, as Blaža mentioned, and how the preparations are ongoing. Are the preparations for mediation in terms of timing, the space, education for all parties went fine. The entire process of mediation, if we move to the second stage, it is very important if the parties are informed about the mediation. Do they know what is going to happen there? And after that, also the work of the mediator is of great
I'm sorry to interfere.
Importance.
Excuse me, apparently there's no translation to Albanian. I'm sorry. Is this correct? And maybe could you please check interpreters to ensure interpretation to Albanian, because I think it would be really a shame if Albanian speakers could not follow your intervention, Gordana.
I think you are correct. There are not any translation in Albanian version.
Okay. Translators, could you please check? Why is no Albanian translation? It's okay now. Okay, thank you very much. Thank you, Gordana. Sorry to interrupt you. I'm sorry, now there was no translation to
Just a moment, we're trying to sort things out. Just a second.
Okay, now the English is coming. I was translating into Portuguese. Can you hear the Albanian translation now?
Could you please give feedback? Is there Albanian translation and French? I'm on the front.
Ne znam, da li da pređem, should I switch to English, Carla, maybe?
Yeah, for me, this would be very helpful, but I think it doesn't help for those following on the Albanian channel. So maybe we quickly, interpreters, do you try to figure this out, or? Is the Albanian? Here should be Albanian, right? In the French channel. Okay. Could I get some feedback from the interpreters? If okay. Feedback from the interpreters if you can sort it out. If not, I would ask Gordana to continue in English, maybe, since this might be a language we all can follow a little bit.
Now I switch to English channel. Is it okay?
Yeah.
Do you hear me, everybody?
Yeah, please switch to English channel and follow
Yes.
Gordana in English. Thank you.
Please. Yes. Then in our association, you know, we thought that it's very important if we want to evaluate a system, a program of one organization or even court, to have this evaluation from the parties through evaluation list. And of course, this evaluation must be scheduled in quality way. It must be measured through the process, not just the mediator and so on, the process, the mediator, everything. Then, of course, it's very important how to choose mediator. In our association, we think that it's important to have listed mediators just for our association, you know, because in Slovenia, we have listed mediators for family cases, and they are listed at Ministry of Family. And then we have mediators who are listed at courts, and we are listed at Ministry of Justice. But also in our association, we have now special licenses for our association. It means if you want to choose mediator for private mediation, you could go to our list and choose your mediator. It means this mediator should be trained well, and the training must be special exam, practical role play, which is exam. Then you should be as mediator educated each year. You have to pass the special training. For court mediators, this is 12 hours per year. And you should have intervisions and supervisions if you have some problems with the process or with yourself. And for the end, speaking about qualification and good mediation, each organization or mediator should stick to one code of conduct. You know, it's very important to follow these ethical rules and, of course, to have opportunity for parties to complain, to appeal against your work. And it means you have to have as organization this appeal commission, or at the court, of course, we also have these complaint committees. For the time being, that's it. Thank you.
Yeah, thank you very much, Gordana. Thank you in particular for raising our attention and awareness to all these aspects which can complement and maybe go beyond formal qualification, as you just mentioned, possibilities for the parties to complain and evaluation and the code of conduct. So I think these are all very relevant aspects, and maybe we can come back to these during the discussion later on. So for the moment, it's my pleasure to invite my last panelist, Smilka Gabric. Hello, Smilka. So maybe to introduce you quickly, I'm very happy that you're here, that you're reaching us from Sarajevo, actually from the office of my colleague Emil Krehic. Good to see you and good to see the office. Just to quickly introduce you, Smilka, you're a very experienced mediator. You are, as Gordana in Slovenia, you are one of the first in Bosnia and Herzegovina who has been trained and certified, and we have been trained and certified already in 2005. There have been vast training experiences as a trainer for mediators with the Association of Mediators, CIH, but also the Center for Education of Judges and Prosecutors. I think this is also very relevant experience for our topic here, and the State Agency for Employment of Civil Servants. And I think our colleague Jasmika Pratic, she mentioned you, like that she has been sensitized and trained in mediation as a legal servant, right? This morning in the other session. So you're an economist by training and graduated from the Faculty of Economy from the University of Sarajevo. So I'm very happy to have you here, and thank you very much. I would like to introduce your statement. I would like to ask you the question from the perspective of a mediator, accredited trainer for mediation and educator for judges. What could be done in Bosnia and Herzegovina and maybe also beyond Bosnia and Herzegovina in order to improve the qualification of mediators and thereby to create more trust into the mediation system? Thank you very much, Smilka, for your statement.
Hvala lijepo, pozdrav.
Thank you.
Da podijelim svoja iskustva I naša iskustva u Bosni I Hercegovini vezano za kvalifikacione standarde medijatora koje mi omogućujemo naš sistem edukacije medijatora. Mislim da su u rangu I u liniji sa evropskim kurikulumima.
Smilka, can you hear me?
Bez obzira. Mislim da su...
Are you in the right channel?
Okay.
Sorry to interrupt. I think you're in the English channel, are you? Could you
now we are fine. Sorry, I was told by my colleague to stop, but we are in different channels. I believe now we have the Albanian there, and I am doing the English.
Da li me čujete?
Can you hear me now?
Yeah.
Dobro, hvala. Dakle, što se tiče kvalifikacione standarda naših medijatora u Bosni I Hercegovini, ja mogu reći zaista da su visoki. Vezano I za kurikulum, vezano I za sam zakon o postupku medijacije koji ustanovljava ulogu medijatora I vezano za njegovu dodatnu I permanentnu obuku koja po podzakonskim našim aktima predviđa 2 dana godišnje znači obavezne do edukacije, mada mogu reći da većina na individualnom nivou, znači učešća na ovakvim konferencijama, okruglim stolovima, pisanje članaka, knjižica i tako dalje. Bez obzira na ovo sve, ipak imamo i određene izazove, da tako kažem. Prije svega i kurikulum je datira iz 2005. godine, znači vrijeme je da se malo i updateira, da se porazgovara u regiji o tome i da idemo na neke zajedničke platforme oko edukacije i tako dalje. Zatim, pitanje trenera. Znači, evo, da uzmemo paralelu u sportu, pa vidite vi koliko su treneri nagrađivani, traženi, imenovani u svijetu, mi znamo, evo uzmemo fudbal koji svi gledaju. Šta znači dobar trener? Znači, mi u medijaciji moramo za trenera imati...
I'm sorry, Smika. Just one moment. Could you quickly check if you are in Portuguese channel or if you're speaking in the English channel?
Just a moment. Čujete li me sad?
Because it's in
Can
English.
You hear me now? Can you hear me now?
Yeah, now it's better. Yeah.
Sad je bolje. Despite of all these premises that ensure the quality of the mediators and its qualification, still we have many challenges. As I mentioned, the curricula is since 2005, it's final time to update, adopt, and to discuss it in the regional level, to agree on that level. And then the trainers are of great importance. We mentioned the case of the football. The coaches are well known globally, and they are being appointed. And I believe also the trainers in the mediation should be the most experienced, well-trained in Bosnia and Herzegovina. Latest several years, we don't have huge interest when it comes to the training of the mediators. We have annually one training which involves about 12 participants. When it comes to the other aspect related to the role and good and offering good quality services and the trust on the mediators, of course, that the mediator cannot be considered separately, always in within the scope of the within the scope of the we say constitution and so on, regardless how much we would like to sensibilize them. When it comes to the mediation, we could say that we have some relation which has certain hesitation, which has to be improved, because we believe that our judges can be stimulated. If me as a mediator, if I handle a case, we say in the judiciary, the judge will be kind of scored as if he was the one who was successful during the mediation process. So we have to see some way how can we improve these things. It is of great importance that the judges who propose the parties, but also they have the possibility to suggest to all parties to take a mediation process, but they have to be trained to understand what is the core of the mediation itself. And the third element in this is lacking of practice. How can we, or lacking experience, how can we improve our experience when we talk about judges? We would say that cases the court has dropped very much. We don't have the possibility. We have some, you could say, we have some difficulties. we say the judges do not promote us, and we as an association don't have the possibility to do the promotion of the mediation. So maybe we could see earning experience and getting more job would be if we could have a mandatory mediation of certain cases. There was a booklet that was written about the analysis of the process of mediation. We have suggested such mediation in all cases which are based on, we say, agreement. Why? Because in this kind of cases, it is normal that the parties agree themselves. I would like to conclude when it comes to the recommendation in the regional level, and it would be to have a platform to work on exchange of curricula in our country, to in regional level see how we could promote we mediators personally, ourselves and our profession. And after all, we have a European direction. We can always harmonize with the European directive. We have this possibility, interborder mediation, and to see also the mandatory thing like the example of Serbia and so on. Thank you very much.
Thank you very much, Smilka. Thank you very much for the intervention. I was not too strict on the time because we had so many complications. The same for Gorana with translation. So, but I hope it was still good and fitting our time frame generally. So, thank you very much for raising, in particular, the regional aspect, Smilka. I think this is very interesting since it's also like a regional conference and meant to strengthen the network, which is already existing, but strengthening the network among different practitioners. So I think this is very true. Okay, thank you very much. Unfortunately, we only have 10 minutes left. Actually, I thought we might have more, which is a little bit due to translation problems also. And I would really like to invite all participants to ask some questions. Elmar, do we have any questions for the moment?
Not yet.
Not yet. Do you have some? It's a very good opportunity to ask some questions and to make this more of an interactive experiences. But maybe in order to make use of the time, I would maybe quickly come back, not in the order we started with, but Plato Nedic has a question, so I would give you the floor. One moment. I invite you to come here, and I will unmute you. You are unmuted. So I can't hear you.
Não pode, porque você não pode join que os outros não leave.
I'm sorry.
Shall I move to English?
Yes, now in English.
Now, okay. Smilka, when you mentioned mandatory mediation in all disputes that are based on contracts, did you mean contractual clauses on mediation, inserting contractual clauses on mediation in the contracts and giving a mandatory effect to those contractual clauses? Because situation in Serbia now is, even if you have mediation clause in your contract, one party sends the case to court immediately. The court has no power to reject the case because of the contractual clause. The court can just say, look, guys, you have a clause in your contract, but has no power to stay or to reject the proceedings at the moment in Serbia.
Thank you very much. Do you want to react to this question, Smilka, since it was directed to you?
Yes. Can you hear me? Can you hear me? Of course, there are two things here. One is putting a clause in the contracts concluded by the parties, and the other thing is the question about cases that are referred to the judges. Sorry, referred by the courts, and these are the cases that we have decided not to change the law, but in the niveau of the regulations through high, we say, chamber in the level of courts to make a selection within the uh, uh, records office to refer what is for mediation, what is not. If this is the first choice, why not to go straight through the mediation? What cannot be handled through mediation goes to the court, and this is very simple, and it could be easily regulated. No need for huge legal interventions.
Thank you very much, Nika. Here was another, oh no, there was no other question, but maybe we can use, maybe the other panelists have a reaction to Blažo's question. Was this, yeah, Gordana? I ask you to unmute. Please unmute. Please unmute yourself. Thank you.
In Slovenia, in such a case, which Blažo asked, the judge will dismiss the case, you know. It's not allowed. If it's the contra the right clause, mediation or ADR or arbitration clause, it's not allowed to sue, and the case is dismissed. It's too early, you know. So it's, but I would be, you know, very much in favor. I proposed this in Slovenia several times without success, that we should put in our material obligation law that such a clause in commercial contracts are obligatory part of the contract, you know. And just in commercial, not in all civil cases, you know. But the Ministry of Justice didn't want, you know, even to begin the legislative changes for such a article in our obligation code. This would be very effective if we could pass this in European Union. I hope it will be one day.
Carla, may I have a short intervention or comment?
Yeah, please. Yeah.
Okay. It's good to know different perspectives about the quality of mediation, and it's much related to the increased professionalism of mediators in general, and also trust, and also to be more productive.
Maybe
and,
that we can bring you to, thank you. Yeah, this is what I asked for.
Okay, and my question is for Gordana and also for the others. Do you have any development tools for assess of quality of mediation and quality of the process? And if yes, it is visible for all of mediators, and also for sharing some finding or in a regional level? Thank you.
Hello, Rasim, nice to see you. Yes, in court system, court annexed mediation, which we now having in Slovenia, we have exact tools to measure the quality of mediators also. And each year, each mediator should be evaluated through the evaluation lists from the parties and through the head of the program at the appeal level. For instance, that's me. And if there is some complaint against mediator, I go and co-mediate the next mediation with our mediator, you know. just to try to check and to work with this mediator, how it's, you know, the process being around. And yes, we have these evaluation lists, and each year this mediator should be evaluated. But in private practice, you know, we don't know about this, you know. So I told you before that our association really are very strict in these rules, what we expect from private organization, which rules to respect, to give some quality or guarantees of quality for the parties, you know. And one of these is really this evaluation list, this possibility for parties to complain, to measure their net success. This is not important for me, you know. As quality mediation, it's not very important if the mediation was successful or not. The important is for the parties, did they have all ruled basic principle, you know, and at the end they should have this opportunity to fulfill evaluation list. But some our private organizations in Slovenia, they don't want to give us any results, you know, no results. So even as trainers, you know, we have some private organization with trainers who even didn't mediate, you know. Can you imagine trainer without mediations? In our association, one of the obligatory condition to be a trainer is to be not just trained as trainer for mediators, but of course to mediate.
Yeah, thank you very much. Thank you, Rasim, for bringing up this question of evaluation, or like coming back to it. And thank you very much for your answer, Gordana. You actually, maybe some of the other panelists want to say something in this respect, maybe in respect to the questions, what else could be done in order to ensure quality apart from formal education. And we also, I see you, Yusuf, you also, Plajo, you posted several questions into the chat. Do you want to ask them yourselves? Then maybe I would say Yusuf with your contribution and question, and then Plajo. And then maybe we try to wrap up the panel, because we otherwise we will be very late. Okay, thank you, Yusuf.
Yusuf. Thank you very much for the questions by the expert of mediation in the Republic of Albania. I was fortunate to meet him and have discussions with him. It is a very well thought and very well raised issue. In Kosovo, we have a mechanism, which is a direct mechanism with regards to the quality check of the mediators. We have inspection of mediators on discharge of their duties. It's a mechanism within the Ministry of Justice, a mechanism which conducts inspection of all the free occupations or professions in Kosovo. It's a direct monitoring. However, we have also indirectly the prosecutorial and also the court system, where they evaluate all the cases that are referred by the prosecution office and by the court. And of course, that's one evaluation takes place about the professionalism of the mediator when it comes to the resolution of the dispute and also the quality of mediation. And we have the third possibility, which is the evaluation for those cases which are with the self-reference, where the agreement of the mediation, when it fails to be enforced by the free will of the parties, and then we have to send them to the private enforcers, and then indirectly we can view what is the quality of the mediation and can it reflect successfully for the enforcement. And that's why it's there to have an appropriate title for the execution of enforcement of the mediation through self-reference. Another tool for the mediation, I think there are many components in this regard. However, the mediation should be qualified as an integral part of the judicial system and in no way to be viewed as a satellite or something which is detached by its orbit, but it should be a part of the judicial orbit in a drafting of policies, in the harmonization of legislation, but also to the part of accountability. As soon as as long as the mediation is viewed as a satellite which is detached from the judicial orbit, then we are not in the right path. Well, I would like to take this opportunity and to say that the mediation is a right hand of the judicial system in a positive sense. And I'm speaking about for all the countries that are part of this conference. We have the legislation base, we have the mediators, we have the mediation, we have all the tools, mechanisms in place. Why we have such a huge backlog? Let's say in all the countries, it was a common concern. It is because of the fact, because we have not put the mediation in the appropriate place with the judicial system. As long as we do not have a meritorious place of the mediation in the judicial system, then at all times we are going to view the mediation with that evaluation through the eye of the evaluation that it is not well developed. It did not produce the efficiency when it comes to the resolution of the disputes and to provide like more to assist the judicial system in general. Thank you very much.
Yeah, thanks a lot also for complementing a little bit the discussion. Okay, what else could be done like in order to ensure quality? Thank you very much, Yusuf. Blaju, you put, as I said, some questions into the chat. This is also why you're still with us. So do you want to?
I wanted to, thank you, Carla. I wanted to ask any of the panelists briefly, can you recommend here any minimum standards for the trainer? Gordana mentioned training of trainers and cases. How many cases? What are the standards that should be a minimum standard for somebody to be a mediation trainer? Because we are trying to revise the law in Serbia. Thank you.
Okay, thank you very much. That's a very concrete question. Okay, where regional exchange can be very fruitful. Okay, please. Who wants to say something? One of the panelists. Gordana, I see. Well, yeah, Isu?
Well, in our association, we have just, accepted the rules who could be the trainer, because we have trainers, regular trainers in our association and invited trainers, so-called ad hoc trainers. Well, a regular trainer should have, of course, basic training, some advanced trainings, train the trainer for mediators, and of course, train the trainer for mediators. This is 3-4 levels. And of course, he or she should be a regular mediator with many, we didn't say how many cases, but many cases, And of course, we have some specialization in family cases, in labor cases, civil cases, and so on. And our trainers are not just lawyers, judges, notaries, professors at law school, but also psychologists and social workers. And now we are preparing one quite big training for social workers in Slovenia. And of course, we choose the right trainers for such a specialized training. This is quite special because we don't believe in Slovenia in mediator as profession. We believe that mediator could live on mediations if he or she could have enough mediations, but we don't, want this to be profession, because If you're a professional mediator, then you have to care first about yourself and your family, and later about your parties, you know. So, but for trainers, these are demands.
Yeah, thank you very much, Gordana. And then we have Isuf and Brunilda will also say something and share. And please, could you maybe try to be short, and then we will really wrap it up also for the participants to know. We will try.
Thank you very much. I'm just speaking on behalf of from the aspect of the mediation, but also the researcher in this mediation. So, which mediator reflects a successful in order to have him uh, to consideration or training to select him. Mediator is successful when he knows in depth the legal system of the country. He knows very well the circumstances and mindset of the country where she operates. And the third element is the psychological aspect, which is of high importance for a mediator to be. And also the mediation techniques that we as a mediators, we have them in mind, the manner of communication with the parties, which falls within one of the things that make a mediator successful. And also we call it the professional drafting, legal drafting of the mediation agreement. And all this we have to convey to the trainer for the mediators. He must be a very good to have a very good knowledge of the legislation of the country, should be have a good knowledge, psychological knowledge, how to communicate and appear in the hearing, and also how to ask the question, but also a very good in mediation techniques, and also to have a high knowledge of the legal writing and drafting, because the entire process of mediation is intertwined with the mediation agreement. Mediation agreement is what produces the legal effect for the parties, and the parties then can have the access to justice and to, let's say, to implement the agreement. Thank you very much.
Thank you, Isuf. Yeah, the last word goes to Brunilda.
Referring to the experience in Albania, from Albania, the training in Albania, it goes without saying, are provided by the National Association of National Chamber of the Mediators, and the experience shows that the training can be provided by other important stakeholders. As in Albania, we have now organizations that have more than 2 or 3 decades that are involved in the mediation processes, and with the high valuable knowledge. Also, the university centers who have sufficient capacities to provide training through the qualified trainers. And an issue which emerges as a direct one is perhaps, Blazo, I mentioned that with the cases, in how many cases a mediator should have been involved to consider it as a minimum or the threshold for him to become a trainer. So here it is said that if that mediator has not addressed any mediation process in the last 2 years, in the past 2 years, then he will lose his right to exercise this the duty as a trainer. So here I'm bringing the concerns of the mediators from Albania, because if this doesn't happen, they are afraid for losing their licenses and mediators if the training is not provided, and if someone does not resolve any case, then probably they will lose their right to discharge their task as a mediator. Therefore, more cases we address or we are involved as a mediators, better we become as a mediator. So my proposal is to establish a flexible legal framework to look forward to provide the possibility to enhance the standards of mediation. Thank you very much.
Thank you very much, Brunilda. Thank you very much, Blažo, for the question. Actually, I like it very much that we are using this panel for direct regional exchange, which might have like an influence on Serbian legislation. I think this is a very good way to benefit from the conference and the panel. Thank you very much, dear panelists. I enjoyed very much your contributions as the participants did. I think we saw that quality actually is not as bad as you might think, or actually the standard is quite high. The mediators are quite critical. And we also discussed different measures which go beyond formal qualification. And there I also enjoyed very much the ideas and inputs from the different country contexts. And I think this was very fruitful. Thank you very much. And thank you very much for your patience. And thank you very much for your patience in particular when it comes to translation. I'm very sorry that we had again translation problems, but you bear with us. Thank you very much for this. And now I would like to conclude this panel, and we will see each other at 12 under the old link. If you want, I will post it. I will post the old link into the chat so that you can directly connect here. Please enjoy your well-deserved break. Thank you very much.